आपने शायद गौर किया होगा कि जब हम चलते हैं तो हमारा एक पैर हवा में होता है, एक ज़मीन पर, एक आगे होता है, एक पीछे। मगर आगे वाले को कभी ये अभिमान नहीं होता कि वो आगे है, ना ही पीछे वाले को कभी ये अपमान महसूस होता है कि वो पीछे है। क्योंकि दोनों को ही पता है कि कुछ ही क्षणों में परिस्थितियाँ बदल जाएँगी। पीछे वाला आगे हो जाएगा और आगे वाला पीछे हो जाएगा। चलना तो ऐसे ही होता है। जीवन भी कुछ ऐसा ही होता है दोस्तों। 2 दिन आपको अपमान के मिलेंगे, 2 दिन आपको सम्मान के मिलेंगे। इसलिए धैर्य रखना सीखिए। बहरहाल मेरा इन बातों का मेरे वीडियो से कोई मतलब नहीं है। दिस वाज़ जस्ट अ पीस ऑफ विज़डम फ्रॉम माय साइड। Good afternoon everybody. My name is Vandana Yadav and today I'll be talking about the Supreme Court new guidelines on the living will. Alfred Tennyson in The Two Voices said, "Whatever crazy sorrow saith, no life that breathes with human breath that ever has ever truly longed for death." And that is so true. No human who is breathing will has ever longed for death. But they do come in situations and conditions in life where you have to long, where you become helpless and you do long for death, like in the case of euthanasia. This term is derived from the Greek word euthantos, which means an easy death. Mercy killing. It is the painless killing of a patient who is suffering from an incurable disease. A 5 judge bench of the Honorable Supreme Court, headed by Justice K.M. Joseph, agreed to significantly ease the procedure for passive euthanasia in the country by altering the existing guidelines for living will as laid in the 2018 judgment in Common Cause versus Union of India, in which passive euthanasia was allowed. What is euthanasia? यूथनेशिया का मतलब होता है इच्छा मृत्यु। यूथनेशिया ये डिमांड करता है कि इंसान की मौत उसे एक डिग्निफाइड तरीके से मिले। कहते हैं मांगे मुंह मौत भी नहीं मिलती। कभी कभी मौत की इच्छा करनी पड़ती है ताकि उसको डेथ भी एक काम और एक पीसफुल तरीके से मिल सके। इंसान ऐसे पेनफुल वेजिटेटिव स्टेट में आ जाता है कि इसे जीने की कोई इच्छा नहीं होती। What is living will? Living will is a written document detailing a person's desire regarding his future medical directive in circumstances in which they are no longer able to express an informed consent, especially an advance directive. इंसान अपने जीते जी यह बताकर जाएगा कि अगर उसे कोई लाइलाज बीमारी हो जाती है तो उसके साथ क्या किया जाए। यूथनेशिया 4 तरीके का होता है: एक्टिव यूथनेशिया, पैसिव यूथनेशिया, फिजिशियन असिस्टेड सुसाइड और इंडायरेक्ट यूथनेशिया. Active euthanasia involves active intervention to end a person's life by actually, with the help of some external forces or external substances, such as administering a lethal injection. Passive euthanasia, on the other hand, refers to withdrawal of life's support system or a treatment which is essential to keep a terminally ill patient alive. आइए देखते हैं कि साल 2018 के पहले यानी कॉमन कॉज वर्सेस यूनियन ऑफ इंडिया के पहले क्या सिचुएशन थी। सो इन पी रत्नम वर्सेस यूनियन ऑफ इंडिया द सुप्रीम कोर्ट सेड एन एक्ट ऑफ सुसाइड cannot be said to be against religion, morality, or public policy, and an act of attempted suicide has no baneful effect in society. 2 years later, this was said in 1994, and 2 years later, in Gyan Kaur versus State of Punjab in 1996, the Supreme Court held that right to life did not include the right to die, and only a legislation could permit euthanasia. In Aruna Ramchandra Shanbog versus Union of India in 2011, Supreme Court allowed passive euthanasia for a nurse who had been sexually assaulted in Mumbai in 1973 and had been a vegetative state since then. The court distinguished here between active and passive euthanasia and allowed the latter in certain situations. इसके पहले साल दैट इज़ 2011 के पहले साल 2006 और 2008 में लॉ कमीशन की रिपोर्ट आई थी जिसमें बोला गया था अ डॉक्टर हु ओबेज इंस्ट्रक्शंस ऑफ अ competent patient to withhold or withdraw medical treatment does not commit a breach of professional duty and the omission to treat will not be an offense. The Law Commission also recognized the patient's decision to not receive medical treatment and said that it did not constitute an attempt to commit suicide under Section 309 IPC. In 2018, Supreme Court allowed passive euthanasia while recognizing the living wills of the terminally ill patients who could go into a permanent vegetative state and issued guidelines regulating this procedure. These were guidelines issued and it was held by a five-judge bench headed by the then Chief Justice of India, Justice Deepak Mishra, and it was held that these guidelines will be enforced until the Parliament passed any legislation on this. By far, no law has been made on the subject, and this has rendered the 2018 judgment as the last conclusive set of directions on euthanasia. Who filed this petition? But a couple of weeks before, a petition was filed. Who filed this petition? The petition was filed by a non-profit association that submitted that the 2018 guidelines on the living wills were unworkable. A couple of weeks before, the cumbersome process has been made easier by Honorable Supreme Court. तो 2018 की गाइडलाइंस में लिविंग विल was required to be signed by an executor in the presence of two attesting witnesses, preferably independent, and to be further countersigned by a judicial magistrate of first class. The treating physician was required to constitute a board comprising three medical practitioners for various fields of medicine with at least 20 years of experience. Now, these board members would decide whether to carry out the living will or not. If the medical board granted permission, the will had to be forwarded to the district collector for his approval. Now, the collector would then again form another medical board of three expert doctors, including the chief district medical officer. This cumbersome process has been made easier a couple of weeks before. Firstly, instead of the hospital and the collector forming two medical boards, both the boards will now be formed at the hospital level. The requirement of 20 years of experience for the doctors has been relaxed to 5 years. The medical board must communicate its decision within 48 hours. Earlier, there was no such time limit. The 2018 guidelines required two witnesses and a signature by the magistrate. Now, a notary or a gazetted officer can sign the living will in the presence of two witnesses instead of a magistrate's countersign. And lastly, in the case of medical boards set up by the hospital refuses permission, it will now be open to the kin to approach the High Court, which will form a fresh medical team. Thank you.